Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying our legal education content, please remember to subscribe. It helps the channel grow. For today's case, we're dealing one that will be of strong interest to the auditor crowd, the First Amendment auditor crowd. This should be of a lot of interest to that group of people, which I know that there's a healthy subset of them on my channel, so this should be of paramount interest to you. This is the case of George Wingate versus Scott Fulford and Dismes Piston and S.A. Fulford. In this case, the police detained someone for not giving them ID or not identifying themselves. And so the Court of Appeals has to analyze whether or not they were required to identify themselves and if the officers did it bad. So let's learn a little bit about First Amendment law. Let's learn a bit about requirements to give ID. Let's learn a little bit about auditing the auditors. Let's get started with this. In the early morning hours of April the 25th of 2017, Mr. Wingate was driving southbound on Jefferson Davis Highway in Stafford County, Virginia. At some point between 1 and 2 a.m., Wingate's check engine light came on. He pulled his car off to the side of the road and parked it in front of a CarStar car dealership under an illuminated streetlight. Mr. Wingate left his lights on, popped the hood, and began to investigate. Around this same time, Deputy Fulford was driving northbound on the same highway. The deputy saw Mr. Wingate's vehicle off to the side of the road. The deputy was concerned that the car was disabled, so he turned around, pulled behind Mr. Wingate, and began to get out of the car. So maybe this officer had some good intentions at the start, but of course it goes downhill from there. Deputy Fulford then requested Wingate's identification. After Mr. Wingate asked why he had to disclose his identity, Deputy Wingate activated his mic and requested backup. The two men then engaged in the following exchange. Fulford, well, in Stafford County. Wingate, I'm going to do it without names because it'll be too complicated. Well, in Stafford County. Have I committed a crime? It's required. Have I committed a crime? No, I didn't say you did. All right. So you're still required to. Am I free to go? Identify yourself. Am I free to go? No, not right now, no. Am I being detained? You're not detained. Am I free to go? No. Am I being detained? If I'm not being detained, then I'm free to go. You're not free to go until you have identified yourself to me. So yeah, the officer may not fully appreciate the word detained, because if you're not detained, you would be free to go. And so he's asked, am I being detained? He says no. And then he says, am I free to go? No. Those statements are in conflict. It's like, well, no, if I'm being detained, I'm allowed to leave. It's like, you're not allowed to go until you identify yourself. Okay. So, he doesn't want to identify himself for whatever reason. Maybe he has to, maybe he doesn't. That's what we're going to learn a little bit more in this case. But this guy doesn't want to identify himself to the officer. And so, he's calling for backup and all the rest of it. So let's learn what happens next. Eventually, the officers attempt to arrest him, citing Stafford County Ordinance 17-7C. 17-7C makes it a crime to refuse an officer's request for identification if the surrounding circumstances are such as to indicate to a reasonable man the public safety requires such an identification. So Stafford County has an ordinance that seems to suggest you have to identify yourself. Okay. Now this is where things get a little bit not great for the auditor crowd. Don't do this. Mr. Wingate resisted the officer's attempt to place him in handcuffs. Eventually, he broke free from the officers and began to flee, running across the street and out of the dash camera's frame. Yeah, if the officers are going to arrest you, they're going to arrest you. Please don't resist arrest. Because, first of all, you can get seriously hurt. So there's a real physical danger. And second of all, the resisting arrest charge might stick, even if the reason for arrest is not valid, depending. So, I would not recommend this. But he went with the flee from the officer's approach. And, yeah. So the officers then eventually throw him to the ground, put him in handcuffs, and place him in the back of the patrol car. The officers searched his car instant to arrest, and the officers revealed a bag of tools, a pair of gloves, and a title certificate. Mr. Wingate was charged criminally for failing to identify himself, intentionally preventing a law enforcement officer from lawfully arresting him, knowingly attempt to intimidate or impede a law enforcement officer. That was just total bullshit. And possessing an open title certificate of title. And apparently he had this title certificate because he bought a car. This wasn't the car he bought, but he had the certificate of title for this other car. So it was legal, but apparently whatever. Okay, but on the date of trial, the prosecuting attorney dropped all the charges. The attorney informed the deputy that defense counsel had brought up some case law that appeared to make the charge unconstitutional. So then Mr. Wingate files this suit claiming violation under 42 U.S.C. 1983. So yeah, the attempt. So intentionally failing to identify himself, preventing a lawful enforcement officer from lawfully arresting him. Lawfully arresting him is probably the key part of that sentence. So your mileage may vary in other states, even in Virginia. So again, I wouldn't recommend it. But apparently in Virginia, this was not illegal because it wasn't a lawful arrest, because the underlying charge wasn't lawful. Then we have the knowingly attempting to intimidate or impede. That's obstruction, and that's just bullshit, because that's not obstruction. It's not even close to obstruction. And this possessing an open title, which apparently was fully legal. So, it didn't matter. So then he files suit and, says, my rights were violated. So let's figure out if my rights were violated. Okay, let's do that. The Fourth Amendment protects the rights of people to be secure in their persons against unreasonable search and seizure. These protections extend to brief investigatory stops that fall short of a traditional arrest. That would be Terry stop, right? For investigatory stops, the balance between public interest and individual right to private security tilts in favor of a standard less than probable cause. To that end, law enforcement needs only a reasonable, articulable, and particularized suspicion that it's engaged in criminal activity. This should sound familiar because this is Terry, right? A reasonably articulable suspicion. It's much less than probable cause, but the court notes the standard that does request probable cause does not mean that it's illusory. So it's not much, but it's something. An officer who stops and detains a person for investigative questioning must be able to point to specific and articulable facts, which taken together with rational inferences warrant the intrusion. Quoting Terry, it's all Terry, it's Terry all the way down. We've often emphasized that the Fourth Amendment requires particularity, a particularized and objective base for suspecting this particular person of criminal activity. All right, so if you want to conduct a Terry stop, you have to have some basis or combination of bases that makes the stop particularized, right? You have to have some reason to think the person might be violating the law of some kind, and then you have to conduct the stop as long as it takes to do that. But you can't arrest. You can't arrest under Terry, because to arrest you need probable cause, right? So Terry doesn't give you the basis to arrest. It gives you the basis to do a brief detention, which is not the same as arrest because of, again, Terry. But so let's figure out if the police broke those guidelines. To be sure, the deputy did not trigger the Fourth Amendment protections by merely driving up to provide roadside assistance. Yeah, that's true. There's nothing stopping the police, because the police generally can do anything an individual can do, right? The police don't lose power by being private citizens. So they, generally speaking, can do anything a private person can do. So could a private person see someone on the roadside, pull over and ask, are you having trouble? What's your name even? Sure, you could. Could the other person tell him to pound sand? Yeah. But so the officers didn't do anything wrong by pulling up and, what's the trouble here? What's your name? The guy didn't do anything wrong by telling him to pound sand either. So, okay. Unfortunately, the officers told Wingate he was not free to leave until he identified himself. So that becomes non-voluntary at that point. So we've moved from a purely voluntary interaction to a non-voluntary interaction, right? When the police come up initially and just say, hey, what's your name? Probably voluntary. But now he says no, so we've moved into a non-voluntary context. So this unambiguous restraint on liberty converted the previously voluntary encounter into not so much an investigatory stop, which comes with, its own protections. They're Terry. They're not a huge amount of protections, but there's something. So, there's that. The deputy argued before the district court the stop was constitutional because, at that point, he suspected Mr. Wingate was engaged in criminal activity, specifically larceny. All right, so he thinks, the officer says, the reason that he stopped this guy is because of larceny. And more specifically, he thinks that this guy is stealing catalytic converters, which is a thing because of the raw materials inside. So he thinks this guy is engaged in larceny, theft of catalytic converters. So that's why he says that he did this stop. Okay, so let's say the court agreed, citing six factors that would give a reasonable officer constitutionally adequate suspicion. Okay, so what are these factors that allowed this officer to think larceny? Here are the factors. The vehicle is parked with its hood up near a car parking lot, near a car dealership at 1:39 in the morning. The vehicle was in a dimly lit parking lot of a closed and empty business at night, despite better lit areas just down the road. The vehicle was near parked car dealership cars during a period of increased vehicle larcenies in an area known for these vehicular crimes. Wingate exited his vehicle without prompting as Fulford exited his cruiser. Wingate was wearing all black clothing, similar to suspects identified and apprehended during a recent increase in late-night vehicle larcenies. And Wingate said he was having engine trouble, even though the car appeared to be properly idling. So the district court said these 6 factors, in combination, are enough to have reasonably articulable suspicion of larceny. Okay, we evaluate these considerations both separately and in the aggregate, recognizing the factors susceptible to innocent explanation individually might suffice to form a particularized and objective basis when taken together. Ultimately, we conclude the innocent circumstances of this encounter fall short of criminal activity, which is an unexpected conclusion for anyone who knows anything about this field of law, right? The Supreme Court has said that you can take combinations of factors that are innocent, and then together, they're totally reasonable. So you'll see police officers pull people over because it's like, you have out-of-state plates, and you're on a major thoroughfare for drugs, and it's late, and I don't know, something, drugs. So it's a little bit unusual. It is a little bit unusual, and frankly surprising and kind of nice. The court says, actually not enough here. Does this mean that the courts are trying to roll back a little bit? Maybe they realize it's gone too far. Maybe the courts are trying to undo some of this damage they've done in the past. Is this a sign of positive things to come? I don't know. We can talk more about this case at least, whatever signs it might hold for the future. So here's what the Court of Appeals thinks. First, Wingate's vehicle was parked with its hood up near the car dealership at roughly 1:39, although the fact has little to suggest criminal activity. In fact, as Fulford initially reasoned, it does indicate a very specific non-criminal enterprise attempting to identify and remedy car problems, which was his initial suspicion. The officer himself said that. The officer said, I thought it was a disabled car. So, Second, Wingate's vehicle was in a dimly lit parking lot of a closed and empty business late at night, despite better lit areas down the road. We've previously held there's nothing inherently suspicious about driving at night on an interstate highway. Third, Wingate parked near the car dealership cars during a period of increased vehicular larcenies, area known for these larcenies. This factor, too, is insufficiently particular. Courts may consider whether a person is in a high crime area, but simply being in an area where crime is prevalent is minimally probative in a reasonable suspicion analysis. Fourth, Wingate exited his vehicle without prompting, as Fulford exited his cruiser. At Fulford's deposition, he testified that this was a red flag for him. Exiting his car. Okay. From his experience, when someone exits the car and begins walking away from the car, it's because they're trying to get attention off the car. Although we generally defer to officers' claimed training and experience, we withhold that deference when failing to do so would erode necessary safeguards against arbitrary and boundless police prejudgment. Fifth, Wingate was wearing all black clothing similar to suspects identified and apprehended during recent increase in late-night vehicle larcenies. Dark attire might be necessary to sufficiently engage in larceny, but it's far from sufficient. Finally, Wingate said he was having engine trouble even though his car appeared to be properly idling. As any seasoned driver knows, a vehicle that runs is not always runs well. And I have a very particular story about that, which I guess I'll share after this. It's therefore unreasonable for an officer to assume deceit from a person claiming car trouble, simply because the vehicle appears to be functional at a glance. These factors do not fare better when viewed together. We need no further than when Deputy Fullard's own words to conclude the first 3 factors, when viewed as a whole, indicate a car in distress, not criminal activity. In the dashcam video, Deputy Fullard explained why he pulled over Wingate. I drive by and see someone with the hood up, so I guess what am I going to do as a police officer? I'm going to pull over and try to help that person. The insufficiency of the deputy's suspicion is apparent when we compare it to the type of suspicion that we found to be adequate in other cases. Mr. Wingate's arrest was likewise unlawful. Every arrest, seizure, having the essential attributes of a formal arrest is unreasonable unless supported by probable cause. But guided by precedent, we hold the ordinance is unconstitutional when it's applied outside the context of a valid investigatory stop. So even if the ordinance is valid, if the stop was valid, because it was invalid, the ordinance is invalid. The Supreme Court's seminal cases on the stop and identify statutes are Hibble and Brown. Brown involved a Texas law that made a criminal offense for someone to intentionally refuse to report his name and residence address to an officer who had lawfully stopped him and requested the information. Invoking the statute, the officer stopped Brown and asked that he identify himself. Although Brown was walking in a high-crime area and looking suspicious, the officers did not suspect him of any criminal activity. Hill then answered the question that Brown left open, whether a state may compel someone to disclose his or her name in an otherwise valid Terry stop. The Supreme Court held that the use of stop and identify statutes within this context because it properly balanced the intrusion on the individual's interest with promotion of the government's interests. The Hibble case also found that in many respects, the individual and government interests implicated by stop and identify are coextensive with those implicated by Terry itself. When pressed on the risk of arbitrary policing, Hibble explains that safeguards inherent in Terry likewise constrain an officer's authority to compel disclosure of someone's identity. For example, an officer may not arrest a suspect for failure to identify himself if the request for identification is not reasonably related to the circumstances that justify the stop. Nor may the request impermissibly extend the stop, suggesting an effort to obtain an arrest for failure to identify after a Terry stop yields insufficient evidence. Read together, the relevant case law illustrates that a valid investigatory stop, supported by Terry-level suspicion, is a constitutional prerequisite to enforcing a stop and identify statute. So the police can't just identify you for the hell of it, they actually have to have a valid reason to stop you. The prevailing seizure jurisprudence flows from the idea that short of an investigatory stop, a person is free to disregard the police and go about his business. Deputy Fullard is not entitled to qualified immunity for his unconstitutional investigatory stop. As Wingate argues, the circumstances here are nearly indistinguishable from those of a prior case, a case in which we found officers lacked requisite suspicion to conduct the investigatory stop. The officers in the prior case saw a man, woman, and 2 infant children near 2 cars in a parking lot known for illegal drug transactions. The 2 officers were transferring a child's car seat from one to another. One of the officers approached the group and noticed that the man appeared to be hurrying the woman. When asked, the man told her that the officer's girlfriend car had broken down and had come to pick her up. During the second long conversation, the officer concluded the man was acting evasively because he did not make eye contact and gave mumbled responses to the officer's question, so he conducted an investigatory stop. We found in that case the officer lacked reasonable suspicion, explained the government failed to explain how Shelclum's innocent act were likely to be indicative of sinister activity, and cautioned government must do more than simply label behavior as suspicious in order to make it so. Deputy Fuller's suspicion of criminal activity in this case is on par with that which we found to be insufficient in prior cases, and pales to that in comparison to which we found to be lacking in a different case. Because these cases place Deputy Fullard on notice of suspicion of criminal activity must arise from conduct that's more suggestive of criminal involvement than Wingate's was, he is not entitled to qualified immunity for his unlawful investigatory stop. Thus, that brings us to the end of the discussion of the case of George Wingate versus Scott Fullard. In this case, Mr. Wingate was having some car trouble, and the police officer stopped and asked him for his name. And he didn't want to give it for whatever reason, and then there was a fight over it. And so the Fourth Circuit says, you don't have to give your name absent a Terry stop. And so he didn't do anything wrong. So, the officer did do something wrong by conducting the Terry stop. The Terry stop was improper because he didn't have reasons to conduct the Terry stop, and the failure to ID didn't give any reason to conduct the Terry stop. So the Terry stop was invalid. And so he can sue for 1983 damages under that, and that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.